in the court. You can't handle the truth.
You have been convicted by a jury after a trial of one offence.
Your Honour, my client built his home by the law. Does he have the protection of the law?
Is that true or not?
I object.
Nothing further, Your Honour.
Silence in the court!
My name's Anna Svenson and I'm the Director and Principal Clerk of Svenson Barristers. Thank you for joining me for another episode of Brief Chats, where I meet with barristers to unpack cases, trends and updates in the law. AI has been making waves across every industry, and the law is no exception. But is this a good thing, and what does it mean for clients, lawyers and the courts, and the advancement of law in Australia? From drafting legal documents, recording time and researching cases, to predicting outcomes and automating admin, the possibilities seem endless. But with that promise also comes a fair bit of peril. So today, we're unpacking the good, the bad, and the downright ugly of using AI in the legal profession. We'll talk about the good, the way AI is helping lawyers work smarter and faster. Then we'll look at the bad, the challenges, the issues of data privacy and the ethical questions and risks, right through to the problem of trust when machines start drafting legal documents. And of course, we will cover the very ugly parts, particularly touching on the recent cases where we have seen AI get it really wrong. Joining me today to help navigate all of this is Laurence White, barrister and AI guru, who's been right at the forefront of conversations about how AI is transforming and sometimes testing the practice of law in Australia. So let's have a brief chat. Laurence, thank you so much for joining me today.
Sure, of course.
Now, Laurence, for our listeners, could you tell us a little bit about your practice as a barrister and how you became so interested in AI?
I think I've been interested in AI since I was a kid. I went to the open day at La Trobe University in the mid-70s, so a long time ago. And Eliza, the first ever chatbot, was sort of there on the green screen. And I kind of got entranced by AI at that moment, I think.
So very early adopter.
Yeah.
Wonderful. Yeah. And now your practice as a barrister?
So I guess it focuses on financial regulation. I do quite a bit of work on crypto assets, cryptocurrency type work, FinReg, and general commercial as well. And I also consult on digital finance topics to the Institute of International Finance.
Wonderful. Well, credentials as a barrister, amazing. Interest and investment in AI, fantastic and deep. So I'm really excited to have this chat with you today. So I thought where we could start is to unpack what we're going to talk about today, which is the best parts about AI, the good, the sort of proceed with caution, the bad or the risky, and then the really ugly parts where it has not been great for the legal profession. I think there's going to be some really significant case examples we'll talk about through that. So can we start with some stats on AI though? What I found really interesting is AI is being used by a lot more people than I think I realised. So there was a recent study undertaken by KPMG, Melbourne Business School and the University of Melbourne called The Trust, Attitudes and Use of Artificial Intelligence, a Global Study 2025. And in that study, they reported that 50% of Australians use AI regularly, but only 36% are willing to trust it and 78% are concerned about its negative outcomes. So 50% to me seemed high. But when we think about AI in the law context, how many law firms do you think are using it now?
Look, I haven't done the survey, but there have been surveys done, the penetration of AI into the legal profession is quite high. I think the use cases are there, and the products are also there in the marketplace. We're seeing both increasing numbers of firms, I think, engaging with the general purpose LLMs, such as Copilot for Enterprise, Claude, ChatGPT, Grok, but more particularly, I think, also engaging with the Thomson Reuters, the Lexis, the Smokeballs, the Ciceros, the Harveys, et cetera, in the legal tech space. So, and a lot of those products I've mentioned in the second category face off or white label some of the bigger, more recognised LLMs. So it's quite an interesting mix of direct and indirect reliance on these large language models.
So it's kind of a mix of specific to industry as well as general AI product.
I would say so, yep.
Okay. And what are the best things about AI in terms of legal practice? Like, where do you think it's being used really well?
Well, I mean, I can probably, talk about my own practice more comfortably than that of other practitioners. But I think one of the key use cases that I see that it's very good at is summarising content. So, for instance, unreported cases, they often don't have a head note, so I can quickly download a case, post it to Claude or something like that, and ask it for a case note and tell it what kind of format I want the case note. Do I want quotations? Do I want paragraph references? And it'll give me a very good, quite detailed case note that I can then file away. I can decide whether to read the case in depth myself. I can decide which bit of the case to focus on, or I can feed it into another prompt with, say, 10 or 20 case notes to do a broader study.
So you could have sort of a collation as well as a summary.
Yes, absolutely. And I mean, some of the other things that law firms particularly might be doing with AI, or some of the products are promising this to them at least, say Smokeball being one, is summarising matter files or chatting with matter. So matter, obviously, after a while, there's hundreds of documents in many litigious matters, and to be able to bring up details quite quickly of what was said when, or details perhaps to pull up a chronology. I mean, that's an obvious use case, or pull up a chart of who's who, or table of who's who. That sort of info extraction, I think LLMs are amazing at. Where they're, I think, a lot more dubious at is if you're relying on them for their accuracy without having grounded truth. In other words, without them being able to draw on a sort of corpus of documents.
Okay, and I think we'll unpack more on that soon. But I think back to my days as a junior lawyer and the copious amounts of binders sitting on a wall next to me, and if you knew there was a piece of information in there that you were just trying to find the reference point for, this tool would be phenomenal.
No, I mean, certainly this tool and similar tools, and machine learning approaches as well. Don't forget, so technology-assisted review for discovery, for relevance and privilege. That's perhaps predates LLMs, and it's more around machine learning, but that's been very effective as an adjunct to keyword-based searching, and certainly more effective than, or quicker at least, than going through a set of binders manually.
The paper file. Now, one of the things that I think is really interesting about this space is the cost issue, because all of that admin back in the day would have been charged to clients. But do you think that AI is going to change the way that clients receive bills at the end of the day?
I think time will tell, and I think that if a lawyer is charging on a time basis, there's no justification for charging on the time it would have taken me to do this task without AI. If I am using AI, it might push some lawyers towards trying to monetize that investment in AI, because it's not free, of course, through other means, either through a higher hourly rate perhaps, or through unit-based pricing or outcome-based pricing. But I think, as I keep saying, it's still early days, and I think the effects, the technology is changing quite rapidly, and the market hasn't really settled down on a particular equilibrium or a particular way of addressing this topic just yet.
Yeah, I feel like if we had this same conversation in 2, 5, 10 years, it would be very different.
Well, I think we'd certainly know a little bit more about how things had panned out.
Yeah. Now, one thing that I think is really interesting is this AI use by clients directly. So, I've seen examples of people having AI write them a personal training program, or helping them market research for buying a house and how to bid for and negotiate for property and things like that.
Yes.
Do you think AI will change the way clients research before they see a lawyer?
I think it already has, frankly. I mean, certainly anecdotally, clients are coming to lawyers having already got an answer from...
Yeah, a bit more armed with information.
an answer from the chatbot. The answer may or may not be accurate. It may or may not relate to the law of Victoria or New South Wales or wherever it is. It may well be quite American in terms of the content and the style of presentation. So one of the things with LLMs is that they're very dependent on the corpus of knowledge that they've hoovered up in order to train the model. And of course, there's more American law, more American cases, etc., that have ever been published in Australian or, for that matter, UK, I imagine. And so if you just ask it naively, what's the answer to this legal question without specifying what legal domain you're interested in, what geography and what period of time, you are going to tend to get an answer that's not very relevant for right here, right now.
Yeah, true. And you can't control what's in there.
No, and yet that's right. You have no, there's no real provenance information that's published by most of these LLMs, so you don't know exactly what they've hoovered up in the first place. I tend to think that by far the safest approach, if you're asking for a legal answer to a legal question, is to provide the LLM with some documents, say the relevant regulations, the relevant act, some cases, and then sort of enter a Q&A session with the LLM. But most clients wouldn't necessarily know what are the relevant documents to actually ground that conversation in.
So the job of lawyers is still relevant and protected forevermore?
Look, absolutely still relevant in terms of firstly, most lawyers who are responsible will use LLMs as a tool when appropriate, and in an ethical way. Okay, so, but if a client's gone ahead and done their own research, I mean, that may well save you some time, and they may well. I think where the client becomes unduly wedded to the answer that they've got from an LLM, it might be necessary to sort of talk them down from that position on the basis of the fact that it probably hasn't been prompted in the right way.
Yeah,
I would normally suggest.
And I think a lot of the time people come with an answer, but they don't show the resources they use to get to that point, like the things you're inputting. So, and
also just a sheer answer without understanding the legal context is really not much use. So, I mean, as you know, as a lawyer, every legal doctrine fits like a jigsaw piece in a much broader puzzle. Say all the doctrines of equity or whatever, they all sort of sit alongside one another. So narrow answers to narrow questions doesn't really tell you what legal strategy to adopt in terms of your overall legal issue. Now, having said that, LLMs can give you quite sophisticated analyses of quite complex situations. So, and I think we lawyers shouldn't underestimate the potential, and we should be aware of. I think the key message from a lot of regulators is to understand the tools, and I think we should always be more or less at the cutting edge of what's out there that can help us help our clients.
Absolutely. I think that's a nice attitude to have towards it. So if we then move on to the risks, the limitations of AI, I think this is where things start to get really interesting. Yep. Can you talk to me about where there are risk points or so the orange lights, the amber light that we need to be thinking about in using AI, you know, things like accuracy, confidentiality. I think there's a bit to unpack here.
Okay, so I mean the two big challenges with the use of AI in legal practice are exactly around confidentiality and around accuracy. There are some other challenges with AI around bias, discrimination, around the energy consumption that AI is going to use, the impact on the environment and so on, but perhaps we can put that to one side. I think in terms of accuracy, the sort of academic studies that I've seen that look at the accuracy of both general purpose AIs and legal AI tools are not very encouraging. So there was a study done last year, and the data came from sort of April, May last year, of comparing Lexis Plus AI, GPT-4, Westlaw, an AI product embedded in Westlaw, and then something called Ask Practical Law.
So these all law-centric products?
GPT-4 not, and the other three were. And it should be said that this was an American study, but, you know, all like the most accurate was Lexis Plus AI, but it only gave accurate answers in 65% of cases. So in the other 17% of cases, there were hallucinations, and I'll explain what that is. In 18% of cases, they were incomplete answers. Now, at the other end, Ask Practical Law only gave accurate answers and complete answers in 20% of cases.
Wow.
So not great. And GPT-4, which is not even a legal chatbot, did better than Westlaw in terms of accuracy. So these products are improving. And this year, if you did the same this year, I'm pretty confident that the score, certainly for GPT-4, would have come a long way. And I suspect probably for the others as well. That sort of surprises me in a way because Lexis, Westlaw and Ask Practical Law, they're marketed as RAG or Retrieval Augmented Generative AI. So in other words, they sit on top of a database and they sort of query the database according to what your query is. Whereas GPT-4 is essentially relying on its training memory. Although there are now extensions of GPT-4 where you can sort of tell it to go and find cases. The problem with those extensions is typically the big repositories of cases won't allow the robots to come in and download cases directly off them. So Ostly, for instance, Jade, etc., they won't allow your favourite chatbot, in my case, say Claude, to just download a judgment. So I've still got to go and do it with my log on and password and feed it to the LLM.
Now, there was something you touched on there that I really want to talk about more, and that's hallucinations.
Sure.
Can you explain to our listeners what they are in legal and where have we seen them come up?
Right, okay. So hallucinations are basically fake facts or made up facts. And the best example in the legal sphere is fake citations. So you might ask an LLM, like if you're naively using an LLM, you might say, explain the law of trespass of vehicles or something like that. Mm-hmm. And it might spit out a sort of long answer that looks very genuine, and a lot of the answer might be made up cases, and it might have quotes in it that are also made up, and that's what's known as hallucinations. So essentially LLMs have been described as autocomplete on steroids, and there is some truth to that. So essentially what a large language model or LLM tries to do in response to a prompt is to come up with the most probable answer to that prompt.
Okay.
And so because they've been trained on so much data, including legal cases, they know what a citation looks like. And the citations look perfect. Like it looks like a case. The citation looks like a case citation. They have paragraph references. They refer to judges, but it's all kind of made up. And so this is why it's actually very, very hard to check this material thoroughly. So I don't actually ask an LLM to give me any kind of legal text like that because I know it's just going to be full of hallucinations.
I think this is such a scary aspect to the AI world. The fact that the products are trained to find an answer or create one if they cannot find it. Is that a correct summary?
I think technically, I think that's in lay people's terms, yes, that is correct. So that's why they're called generative, right? It's also called generative AI because it's wonderful at generating stuff, but it's not necessarily grounded in truth. So where I think lawyers can use AI responsibly is by, as I said before, say, providing the raw materials. It might be commentary. It might be, say, a chapter from a textbook. It might be a regulation. It might be an act. It might be something you've written, a memo or something like that. And if you put it all together, you can get some very insightful output that is grounded in something, and you can ask it to cite that, and you know that it's a real case or a real piece of legislation.
Now, we've had some recent cases where hallucination has been at the centre of what went wrong in the case. Could you talk to me a little bit about a couple of those examples?
Yes, so there's been some pretty high-profile cases here in Victoria. So the first one, I guess, was Dayal, and that's a pseudonym. So it's a federal circuit and family court decision. And in that case, the solicitor for one of the parties to a divorce proceeding they tendered a list and summaries of legal authorities that didn't exist, and it was generated using an AI tool that was within another tool, the LEAP practice management software. So this is the other thing about AI, is you may not always know that you're actually using it, because it's often embedded in other tools. So we've got something like Copilot that's embedded in Microsoft Office and Edge, etc. The solicitor didn't verify the accuracy of those submissions before putting them in, provided an unconditional apology, but yet the court did refer that solicitor to the Legal Services Board here in Victoria, and they've recently handed down a decision where they've restricted that lawyer's practicing certificate, so they'll no longer be able to practice as a principal lawyer. So in other words, they can't run their own firm anymore. They have to essentially practice as an employee. They're not allowed to handle trust money. So it's quite a significant sort of demotion for certainly for a lawyer running their own practice. And there's a 2-year period during which there's going to be supervised legal practice. And the board said the board's regulatory action in this matter demonstrates our commitment to ensuring legal practitioners who choose to use AI in their legal practice do so in a responsible way that is consistent with their obligations. They also strongly advise legal practitioners to refer to their statement on the use of AI in Australian legal practice, and I can talk a little bit about that.
Were you surprised at the penalties given to that solicitor in the Dayal case?
Not desperately. I mean, I think they probably tended to the heavy side of the spectrum, but I don't think it was outside the bounds. I'm not sure if there's been an appeal or an appeal to VCAT or whatever sort of procedure after that. Certainly, the lawyer, would have some possible channels to appeal that, but it doesn't entirely surprise me. No. I think general deterrence is going to play a big role at the moment, just to get this on people's radar, to get them understanding that it is a serious issue.
Well, certainly everyone I was, seeing in the hallways around chambers and things like that had been talking about that case, and I think it's certainly doing that. People are very aware of the risk and the output that AI had in that case, and certainly I think there's more to come. So tell me a little bit about what happened in that DPP and GR case then.
Right, so there were, in the end, there were submissions that were put on that were AI assisted on a legal question, and they were drafted by the Defence Counsel and agreed by the prosecution. And then the day before the hearing on this particular legal question was due to be heard, judges' chambers contacted both parties and noted that they couldn't actually find quite a lot of the references that were referred to in the submissions.
Can you imagine getting that email?
So yes, well, I don't want to imagine it, but yeah,
you'd be stressed.
Yes, and so they then quickly put on fresh submissions that were then unfortunately discovered to also have fake citation issues. So there was a few different kinds of citations, but there were quotes from second reading speeches that didn't happen. There was reference to provisions that had been repealed that had never in fact existed at all, etc. So it was a pervasive issue, and the problem was that the prosecution also confessed that they hadn't checked the submissions themselves. They just agreed with the outcome, and that's why that they'd submitted. And the judge in that case sort of said, at the risk of understatement, the manner in which these events have unfolded is unsatisfactory.
That's a scathing assessment from a judge, though. Often they don't give too many, words of colourful language, so it's cutting.
Well, it is very understated, but yeah, you're right, it is cutting. Now, we don't know what the disciplinary outcome, if any, will be, but clearly it's a salutary lesson. And what is the lesson that I take away is that if I'm going to use AI to help me write submissions, I'm going to check every single reference, and you have to.
What surprised me about that case is that it wasn't an AI stuff up once, it was twice.
Yep.
So the first submissions, I believe, were case reference issues, but the second round was in relation to legislation. Yes,
and I think there's an issue here about just the speed with which, the courts do expect counsel and lawyers to kind of move. And historically, lawyers have been willing to work around the clock and across weekends to comply with these very short deadlines. I think the temptation is to think that using an AI tool is going to save you time, but the temptation is to cut corners. In the end, if you use an AI tool responsibly, it might save you time, but it may not actually save you time.
My observation is it's about changing where you spend time.
Yep.
So if you're going to use it, maybe you're not doing the research yourself anymore, but you are then checking what AI produces.
Yep.
So it's about allocating that time differently.
There's certainly more checking involved.
Yeah.
In my experience, the results are mixed as to how much time one does save. But it does remind me a little bit of the red flag law in England before 1896. Any kind of locomotive that was driven on the road had to be accompanied by a man with a red flag. So the speed limit was effectively walking pace. And it wasn't until 1896 that they took the man with the red flag away, and the speed limit was increased to 14 miles an hour, which at that time was considered incredibly fast. And the point is that we shouldn't have such restrictions around AI that really we don't get any benefit from this technology, because it is quite powerful. But we need to actually focus as you say, on supervision, on checking, etc., if we're going to use these tools.
I thought a piece of the judgment from Justice Elliott was really important. And he said this: the ability of the court to rely upon the accuracy of submissions made by counsel is fundamental to the due administration of justice. Any use of artificial intelligence without careful and attentive oversight would seriously undermine the court's processes and its ability to deliver justice in a timely and cost-effective manner. It is not acceptable for artificial intelligence to be used unless the product of that use is independently and thoroughly verified. So that's paraphrased, but I think it really captures the essence of what that was all about.
Yeah, and an American court in Mata and Avianca, which is the granddaddy of all these fake citation cases in 2023, sort of said something similar. Many harms flow from the submission of fake opinions. The opposing party wastes time and money in exposing the deception. The court's time is taken from other important endeavours, etc. But then there's also a potential harm to the reputation of judges and courts whose names are falsely invoked as authors of the bogus opinions, and to the reputation of a party attributed with fictional conduct. It promotes cynicism about the legal profession and the American judicial system. And a future litigant may be tempted to defy a judicial ruling by claiming doubt about its authenticity.
And we don't want that.
Well, Andrew Bell, the Chief Justice of New South Wales, wrote quite an interesting paper a year or two ago called Truth Decay, where he sort of really links Gen AI with this whole idea of, do we know what's true anymore, and how can we actually verify things? It's well worth a read.
Okay. Now, there's some cases where AI has been used differently, not for hallucination, but to create content that's been consumed by the courts then via submissions that was drafted clearly by an online product. And I think this often comes up with the self-represented litigants.
Yep.
Can you talk to me about some of those cases?
Yeah, so one was May and Costaras, that was this year in the New South Wales Court of Appeal, and there, again, Chief Justice Bell sort of at one point interrupted the unrepresented litigant who was, I think, appealing in that case, and just to ask her gently whether she was reading from something that had been scripted by a chat GPT type product. And she said yes. His Honour kind of made various observations about the quality of the material that were not very complimentary, and a lot of it was irrelevant, basically. However, because she wasn't a lawyer, she effectively doesn't face any sanctions.
True, yes.
There is guidance to SRLs about the use of AI, and essentially they're meant to disclose it to the court and to their opponents. But they face fewer sanctions than lawyers do. But it's certainly a trap for the courts if SRLs are coming prepared with... And Gen AI makes it very easy to produce great quantities of written material.
True.
So there's going to be quite a lot of time, and there may well be quite swinging cost orders eventually against SRLs if they are found to have wasted their opponent's time having to wade through stuff that's basically garbage.
Are there giveaways in there where you read something and you know, oh, that's AI generated?
Yeah, there's quite a few giveaways. One is the use of a lot of bolding, a lot of inline headings that have bold, 2 or 3 punchy words in bold and then a colon. Another one is just not using smart quotes. They use dumb quotes, like smart quotes and dumb quotes. Well, smart quotes do that, whereas dumb quotes just go up and down.
So the incorrect use of grammatical...
No, it's just different characters for, like, smart quotes are just sort of on an angle and dumb quotes are not. The use of the Aptos font.
Really? Down to font?
Aptos is the new Arial, one might say, or the new Calibri, because a lot of the chatbot engines, and the way they format tables is also a bit weird. So if you apply a border to a table that's been formatted with an AI, it'll have a double border because there's a buffer in there. So there are ways that you can pick it.
Okay.
But, more and more people are using Aptos font in all of their emails, and it's clear that they're using chatbots a lot. And I don't think there's anything wrong with that if they're not preparing stuff as a regulated professional, if they're just writing emails. And even as regulated professionals, we shouldn't be scared of it. I think we have to be transparent about what we're doing with it.
Yeah, absolutely. I think that's where it comes in, is if you are acknowledging the product and then using it as a starting point, it's about applying your analysis beyond what is produced at the first instance. That's where I think really
Yes, you can't abdicate responsibility, so it's always your product, even though it's generated by a tool. The temptation is after a while to think, oh, that's a very reliable product, so I don't have to check it thoroughly. And so the temptation is of over-reliance on the output of these products. And I think an associated danger is that you actually sort of switch off your critical brain a bit when you're reviewing the output of that product.
Who do you think is at fault when an error comes up in a court document like that, where, you've got a product that's said to be industry standard or a leading industry product in the legal profession?
Yep.
Is the fault on the product? Is the fault on the person using it? Where does it sit? Do you think there'll be litigation in relation to this space?
Yes, I think there will be, of course. There already is some litigation around chatbots, rather tragic situations involving, children and sort of role-playing models online. In this space, I think, yes, look, the fault is on both parties. The fault is obviously on the lawyer for failing to check the output of one of these because they're known to be unreliable. The fault will probably also be on the product provider if they're making misrepresentations, that it is, as well, it might be industry leading and still be misleading. But the other thing is that they'll be liable for inaccuracies if people reasonably rely on them. So there's the case of Air Canada against Moffat, and in that case, Moffat asked Air Canada through its chatbot for advice on funeral fares, like he had bereavement fares, I should say, and relied on the advice, and the advice was incorrect. Air Canada wanted to walk away from the advice, and the court said, well, the British Columbia Civil Tribunal said, it's your chatbot, you're stuck with the answer.
Oh, wow. You control that at the end of the day.
And I think whether it's a product's liability, typically software won't be a product, so product's liability won't apply, but there'll normally be a lot of contractual disclaimers that the provider of the chatbot will essentially disclaim all responsibility. But a commercial firm engaging a serious provider on a commercial basis should be looking at those exclusions from liability very carefully.
Reading the fine print very closely.
And whether they can negotiate them is anyone's, I don't know.
Do you think that these types of examples, like we've just discussed in these cases, will start to dissipate as lawyers get sort of better at harnessing the power of AI?
I think so. I think inevitably as the products mature and the market engages with them more, people will understand better their limitations, what they're good at and what they're not so good at. And hopefully, and I think it's pretty obvious that that the firms are well aware of the hallucination issues, and the engineers are working very hard to try to eliminate them. And as I said, I think if we replicated the study of hallucinations this year and perhaps next year, the results in my mind would be almost certainly much better. But I think, time will tell whether that issue is eliminated altogether.
Now, confidentiality is something I think we need to delve into a bit more. Talk to me about AI and confidentiality and inputting of data. Like, where does this all sit in the legal profession?
Yes, and the position is reasonably complex, and so I guess lawyers who are using LLMs or chatbots have to be very, very wary of what might happen with the information they feed into those LLMs. So by default, most LLMs tell you that your prompts can train their model.
Okay.
So that the information you put into that LLM in a query or a document you upload can be used by their engineers to improve the model. And the difficulty with that is that it then becomes theoretically available to third parties who are also using the LLM. If they put the same prompt in, let's say you're working for a client who's working on a patent for a particular kind of medication,
okay,
and if you're foolish enough to put in information about that patent into the model, and let's say it hasn't been registered yet, so it's still in the secrecy phase. Potentially, if someone else puts a very similar query into that model, it might spit out information to do with that patent. So
it's picked up that information from the original source, seeking an inquiry with that private information,
yeah,
and then someone else's prompt has drawn that information back down.
Yeah, exactly. And so I think lawyers should be very careful if using what's termed very loosely public chatbots, and that's an example of a public chatbot. So really you should never put client confidential information into a public chatbot. And sometimes it's not even enough to just anonymise information. In that example of a patent, it doesn't really matter what the client's name is. It's more about the business secret that's embodied in the patent. So that's why law firms and responsible legal professionals will be engaging with enterprise-grade LLM products. So Copilot Enterprise, which is offered with most Office 365 Enterprise plans. And there are a number of other enterprise programs that are offered by the big LLMs. So they will offer you enterprise-grade data security and certain promises that the information's not going to go anywhere and that you're not going to be training the model. Now, one of the subtleties is that a lot of the, as I said before, a lot of the software that law firms are signing on to will have an LLM or multiple LLMs in the background.
Okay.
And so do you actually know as the lawyer what the terms and conditions of those LLM arrangements are in the background? Do you know which LLM your client's data might be ending up with?
So it could be like a tower of AI products stacked to give information.
Yeah. Normally maybe there might just be 2 tiers in the tower, but there might be multiple tiers. So really, in terms of responsible due diligence on AI-powered products, you really should understand what is the AI that's powering it and what happens to your data and your prompts.
I think some people feel a little bit comfortable with products like Copilot because it's within your password-protected Microsoft environment, that it's a safe zone and you can put whatever you want in there. Is that true?
I think if you have the green tick inside the shield, that's broadly true. So if it is an enterprise flavour of Copilot, yes, that's true. As for the free version of Copilot, I honestly don't know. There is a middle tier that I should mention, which is the paid plans of the public chatbots that are not enterprise plans. So one example is Claude Max. It's $100 a month. It promises that you won't train the model unless you give the model feedback on its answers. It's not really that clear what exactly that means. And so if you're going to use that kind of plan with client confidential information, you'd be wanting to be very sure that your client was comfortable with you doing that. And they may well be if they think that that's going to provide them a cheaper service or more effective, or if they're very tech savvy themselves or very tech forward, they may well be very comfortable. I mean, I personally have had individual clients who clearly are using ChatGPT or even less secure tools than that. So I think there has to be a space for informed consent here, because I think otherwise some of the cost benefits of AI may not be realised.
Yeah, and we don't get bogged down in regulations so much that we can't use them, but it's about getting the balance right.
Yes, yeah, exactly.
If you were a client right now and you knew your lawyer was using AI as part of your file for your litigation or whatever it may be, would you be comforted or concerned?
Look, I think I'd probably be both. I think it's good to know that the lawyer is, keeping up with technology, but I'd certainly want to see the disclosure in the documentation as to what is happening with my confidential information. Certainly at the bar, we have a cost disclosure document that talks about the use of cloud computing, and that clause was put in some years ago. Now, there hasn't been a similar clause put into the standard form cost disclosure for AI. I have put in such a clause in some of my cost disclosures. Look, the challenge, though, for lawyers using these products is that the terms and conditions change quite
all the time,
often, or all the time, as you say, and at very short notice. So, and unless you actually have a little bot set up to download the T's and C's, you might skip a version. So you really have to engage in a fairly disciplined due diligence process to do it properly, downloading the terms and downloading the privacy policies every week or two at least, and saving them in PDF, or you rely on the Internet Archive, and the Internet Archive is sometimes blocked from some websites, so you can't always rely on it.
Oh, wow, yeah, true. So overall, do you think that AI tools are making good lawyers great, or are they evening the playing field? What do you think is happening in the legal industry then?
Look, I can only speak to the academic sort of literature so far, and it suggests that actually AI has a compressive effect on legal abilities. In other words, that it helps much weaker lawyers or law students, and it actually slows down the stronger students, so it compresses the dispersion.
Okay.
Now, whether that effect is going to maintain itself over time, I'm not sure. I'm just going off 2 or 3 studies published by Choi and a couple of his co-authors in the last couple of years, but really interesting early results and not amazingly positive for the best lawyers.
Yeah. I think my observation with all of this is that there really needs to be more training on junior lawyers about how to embrace the best parts of AI and to recognise where the risks are, because the new wave of lawyers coming through, I think you could reasonably expect that AI is going to be just part of their toolkit.
Yes. Well, look, I think in many cases they will have been self-training, or they might have had some informal training at university or school. But I'm not keen on the idea of a whole university subject on, say, prompt engineering for lawyers or something like that.
You don't think so? I think it'd be good. No?
Well, I think different prompts for different kind of bodies of law, for number one. Number two, by the time the course is designed and rolled out, everything will have moved on anyway.
Yeah, true.
And number three, I think it's more a practical thing that could be taught in the College of Law or during articles or whatever, rather than necessarily uni subject. But I do think it is prompt engineering, and the whole idea of how do you ethically and effectively use AI as a tool is an important bit of practice, certainly of legal practice.
So just as we wrap up, just a couple of final things. Do you think it's inevitable that all lawyers will be using AI in the not too distant future?
No, I mean, I think some of the best or most senior lawyers may well be relying on junior lawyers who are themselves using AI, and some of the most brilliant lawyers will probably certainly still succeed without relying on these tools and using pen and paper and hard copy law reports, just as there are plenty of brilliant lawyers doing that today, even in the age of CD-ROMs.
Yeah, and still having those beautiful paper-filled binders filling your shelves in your office.
Yeah.
Laurence, for any lawyers who want to jump into AI but have a bit of trepidation about it, do you have any tips?
Well, I think jump in is probably the first tip.
Have a go.
Have a go with non-client information, and possibly starting just out of curiosity on stuff that you might be curious about, history of astronomy or whatever it is that you're interested in. And then if you're going to do it for work, I would sign up to a paid plan. I think the added privacy and confidentiality of paid plans is actually really important. And then I would be transparent with my clients if I was using AI and for what I was actually doing with AI. And in particular, if I was planning to share any client confidential information with an AI, I would always have to seek my client's fully informed consent. Look, one thing I didn't mention about confidentiality that's important, the harm and undertaking for litigators. If you're receiving documents from the other side under compulsion, you really have no permission, or there's no possibility of getting consent to share that document with a third party like an LLM.
Just to end with this, what excites you the most about the future of AI for legal?
I think what excites me the most is, I guess, the new legal issues that AI is going to throw up. And I've written a book about this some years ago with a co-author around this possibility of AI as a legal person, for example, about who is responsible when the AI makes mistakes. Is it the provider? Is it the user? Is it the third party who's interacting? And can AIs have legally salient or relevant knowledge, for example? What does it mean for an AI to know something on behalf of somebody else? So for me, those sort of jurisprudential issues are probably the most exciting stuff to come out of AI in the law.
It's the really getting into the nitty-gritty of the AI technology and how it's going to be used, not the productivity necessarily on how it can be executed.
Well, both, of course. Yeah. But I think there's some really interesting, as I mentioned, the chatbot liability cases coming out of the US, and I think there's going to be a whole lot more of those cases in future.
Well, we'll have to regroup in a little while and have this chat again and compare notes on how it's gone, because I think there is a lot of movement in this space and a lot to watch. So, Laurence, thank you so much for joining me for this brief chat. This has been really wonderful.
Not at all. Thanks so much for having me.
Silence in the court.
The information shared on this podcast is for general informational purposes only and is not intended to be advice of any kind. While we strive to provide accurate and up-to-date content, we make no guarantees or warranties about the completeness, reliability, or accuracy of the information presented. Any opinions expressed by guests on this podcast are their own and do not necessarily reflect the views or opinions of the podcast host or production team. The inclusion of any resources, links, or references does not constitute an endorsement or recommendation by the podcast. Listeners are encouraged to seek professional advice specific to their own situation before making decisions or taking action based on the content of this podcast. Neither the podcast host, producer, nor any associated parties will be held liable for any losses, damages, or harm resulting from reliance on the information provided. By listening to this podcast, you agree to this disclaimer and accept that you are responsible for your own actions and decisions.